Good afternoon, everyone, and welcome to our ENS Masterclass, the next installment, rather, should I say, of our ENS Masterclass. Today, we're really excited to speak to all of you about the latest developments in the tax dispute resolution area. It's a really dynamic area, and there's lots of new case law and lots happening all the time. We're going to cover four main topics today, which I'm just going to briefly go through. The first is resolving tax disputes in the High Court and the current judicial landscape there. My colleagues Andries and Peter will take you through that. This is going to be followed by the value of a tax opinion in the context of tax penalties, and Ntebaleng will run that discussion. I will deal with the new tax court rules and the main changes which have taken effect as a result of those. And finally, my colleague Simon will deal with requests for suspension of disputed tax debts and our recent experiences with SARS in that regard. So I'm going to hand over to Andries to get going on our first topic for today. Thanks, Andries.
Thanks, Taryn. Good afternoon, everyone. So yeah, I mean, it's quite an interesting area, the High Court's role in resolving tax disputes. As most of you would have seen, that Minister of Finance has announced there's a shortfall in the revenue collection. So SARS has the obligation to administer the various tax acts and collect revenue. A lot of our clients has experienced increased tax audits last year or so, and I can see that even increasing further. And we've seen that SARS, in fulfilling the mandate of collecting the revenue, they're very aggressive with these tax audits. So when we advise clients, from the very start, when they get the first request for relevant material, they need to understand what is the issue that SARS are looking at, how have they dealt with these issues, and then the question is, through the process, you must always consider, apart from your normal tax dispute resolution procedures as set out in Chapter 9, what alternative remedies does a taxpayer have? And one of those remedies, obviously, is the fact that you have reviews to the High Court, as well as approaching the High Court for declaratory relief. And that's not something new. It has always been there, but you would have seen the recent Supreme Court of Appeal judgment. The most prominent one is the Rappa Resources case that deals with the sort of application of Section 105 of the Tax Administration Act, which, as we all know, says that dispute resolution process should be dealt with in terms of Chapter 9, unless a High Court otherwise directs. And I think that was the issue that came up, is that whenever you approach the High Court, the application of Section 105, should you actually ask for a directive in your notice of motion when you proceed with that or not? Out of abundance of caution, we always has taken the approach to actually ask as one of your prayers in your notice of motion a directive from the court to assume jurisdiction and therefore either hear your review or your declarative. So we always follow that approach as well. And I think, notwithstanding the resistance from SARS, which they vehemently opposes, whenever you give them a notice in terms of Section 11.4 of the Tax Administration Act, that they will oppose that application. So one must use that remedies very sparingly. But I think you need to understand from the outset what are your options in resolving a dispute with SARS, and plan ahead and determine whether an approach to the High Court for either declaratory relief or review relief, or sometimes both, is appropriate, and decide when in the process, if necessary, to actually institute those proceedings. Because the moment you have an assessment or a decision that's subject to objection and appeal, the experience that we have is that a court will be, don't give a direction that it will hear the matter, and that you have to go through the normal tax dispute process, objection and appeal. But as we all know, once you have an assessment, the pay now, argue later rule kicks in. And Simon will talk about our experiences there. But I mean, there also is opportunity, if you ask for a suspension and SARS decline that, you probably would have to ask a Section 9 reconsideration, and then only, if necessary, approach the High Court. So for a review the decision not to suspend or suspend in full. So where does a declarator comes in? Well, if there's a clear point of law on the interpretation, so normally what we do is we approach the High Court if there's a clear point of law. But that's why in your dispute resolution process, you must be very meticulous to try and limit where there's a dispute of facts. Because if you would have seen the SCA case in Absa, although the court and the High Court gave a directive in terms of Section 105, that was a review, The Supreme Court of Appeal said, well, there was questions of fact as well, and therefore on that basis, the SCA said the High Court didn't have jurisdiction. APSA should have gone through the normal dispute resolution process. So obviously, we've been involved in a few of these cases. Peter has been, I've been involved in the rest of our practice. But there are 3 matters going to the Constitutional Court now on the application of Section 105 in the context of a review and or a declaratory application. United Manganese of Kalahari case, the forged packaging case, and the Rapa resources. So this Constitutional Court has issued directions that all 3 matters will be heard simultaneously, particularly in relation to the Section 105 issue. But yeah, I think, you know, the Rapa resources said that 105, you have to ask a directive. And where APSA said the test is, it's nothing unusual or exceptional or all of that. I think the Rapa resources case basically changed the landscape by introducing the so-called extraordinary circumstances, exceptional circumstances test, and where it says, well, a court will only direct if it's extraordinary, unusual, or uncommon, which is quite a high threshold, where I think in the APSA High Court case, the court talked about the appropriate circumstances. I mean, that's what the Medcase case, the Constitutional Court case, way back in 2020, when was it, 2020, or even further back, yeah, and the Bauer-Labuschagne case dealt with that. But I think there's definitely, especially it's a peer point of law. What's the benefit? Well, you avoid the protracted tax court litigation process. I mean, once there's assessment, it's objection. SARS disallow the objection. Then you have to do a notice of appeal. Then you may elect ADR. Then you have ADR. If it is not successful, then you go into the tax court process. You exchange pleadings. You have to do discovery. You have to call witnesses, subject to cross-examination, where a High Court review declarator is on the papers. You file affidavits. When all your affidavits is filed, your pleadings are closed, and then you argue the issues on the papers. So it is you know, substantially shorter process than going through the whole tax court. Because remember, if you get a judgment in the tax court, it's automatic right of appeal to the full bench of the High Court, or with permission of the President to the SCA, and then potentially from there either to the SCA or to the CC. So that there's still a place for that, and I think it's useful. But yeah, we'll see what the Constitutional Court will say on the application of 105. Maybe Peter, over to you. I think you also have some experience on some of these cases. There was a recent spate of cases that you can share.
Thanks, Andries. Yeah, absolutely. Andries and I work a lot on these matters. In fact, I don't think anyone knows more about this area of law than Andries. And I was involved in 2 matters this year, which are quite interesting, where our clients took SARS on review to the High Court. And disclaimer right up front is that we lost both of those cases. So I just want to take you through some of the logic in respect to the judgments in those cases. Both involved errors of law. I think that's important. Andries has mentioned that. So if there's any factual point, you can't go on review, because then obviously you need to go to the tax court and call witnesses, etc. So both our matters involved errors of law, and they were both administrative reviews in terms of the Promotion of Administrative Justice Act, PAJA. So in terms of PAJA, you need to exhaust your internal remedies, which means staying in the tax court, unless there are exceptional circumstances for moving across from the tax court to the High Court. So if your review's under PAJA, you need to show exceptional circumstances, and there's no definition of that. So I'm going to come back to that concept in a minute. Because even if you don't go under PAJA for your review, even if you go kind of principle of legality, for example, you bump into what Andries mentioned, the dreaded Section 105 of the Tax Administration Act. And that seems like a very innocuous section, because all it says is, unless a court otherwise directs, a taxpayer must continue in the tax court. But so what does that mean? A court must otherwise direct. So if you go and say, High Court, I want you to direct me that I don't need to continue in the tax court, the High Court must decide if there are appropriate circumstances for that direction, for not staying in the tax court, for coming into the High Court. And the concept of appropriate circumstances under Section 105 is, as Andries said, now been elevated to an equivalence with exceptional circumstances. So whether you go PUDGA, and PUDGA says you need exceptional circumstances, or whether you go on some other basis, you're going to bump into Section 105. We need to show effectively exceptional circumstances for jumping across from the tax court process to the High Court. And exceptional circumstances is not defined either in PUDGA or anywhere else. So you need to turn to case law for that. In the one matter I was involved in, the Erasmus case, the judge there held that these involve circumstances that are out of the ordinary, unusual, uncommon, or different, which is not really helpful, to be honest. And unpacking those a little bit, in the ABSA case, Judge Sutherland, in his judgment in the Court Quo, said that if you go to the High Court, you avoid, I love this quotation, you avoid the long and protracted slog through the tax court. And those were considered to be circumstances sufficient to go to the High Court. And that's now no longer the case. I think it's fair to say, in respect of the current judgments that we have, this long and protracted slog argument has fallen away. And worryingly, also, if there's an error of law, that in itself does not seem sufficient to constitute exceptional circumstances. So where does that leave us? You've got this concept of exceptional circumstances you need to show, but nobody can tell us exactly what they are, except what they're not. You know, avoiding the long and protracted slog, that doesn't count. A simple error of law, that doesn't count. So it's left us in a state of uncertainty in terms of whether you can go on review successfully. And I think you really need to show, in exceptional circumstances, you need to show something that is now not simply an error of law that's sort of arguable. I always maintain that if the error of law is so blindingly obvious that it's an egregious error of law, a High Court should direct you under Section 105 to come across to the High Court. And the problem in both of our matters is that we didn't get to the merits. We argued jurisdiction. And I think, you know, if you go on a review, you need to insist that you argue the merits, because if there's an error of law and you argue the merits and you can show that that error in law is so egregious and so wrong and so clear that a High Court simply must assert jurisdiction, I think that should be sufficient to show exceptional circumstances. But the problem is that, you know, tax law is complicated, and it's just complicated, and the facts are often complicated, especially in GAR matters. The judges in High Court are often not tax specialists. The second matter we went in, it's a good acting judge, but he'd spent his whole life practicing criminal law. So what does he know about forward sale transactions and the like? So they don't have a lot of experience, and they're often aware that if they make their judgment, if they assert authority and assert jurisdiction and say, we'll hear it in the High Court, and they make an order like Sutherland did, that can be dispositive of the matter. The matter can just go away. And that's quite scary, I think, for a High Court judge. You know, you can just think intuitively, it's much easier to throw it back to the tax court. So I think you really need, you know, and SARS are very focused on keeping taxpayers in the tax court as well. So they've got quite a high-powered team involved in these sorts of matters that we see again and again, exactly the same team in both of our matters for counsel. So, you know, I think one needs to be very prepared and very clear that one has a good argument for review, especially around these exceptional circumstances before one goes that route. But it's certainly a very interesting area of law, and it does involve the long and protracted slog. It takes you from 3 years to a much shorter time frame, you know, so it's something that one needs to sort of consider in respect of every dispute matter. And I'm now going to hand over to Ntebaleng, which is a great segue into the value of tax opinions, Ntebaleng, to make sure you don't end up in tax court and tax disputes.
Thanks, Peter. So I think I know that we are discussing the value of tax opinions in the context of disputes, but I think we should start just with the genesis generally of tax opinions and then go from there. So generally, tax opinions are a risk management tool. So you will have a taxpayer, they either have an internal view on a certain issue or they don't have an internal view. So you'll go to your tax advisor to either get someone to confirm your internal view, if that's, how they're so disposed, or to give you a view which they think is the correct view. And this is obviously good for internally for the taxpayer to be able to do their tax planning, to be able to see that they are treating, applying the right tax treatment, etc., etc. This has also got value in respect of dealing with auditors. We all know the dreaded IFRIC 23, where the auditors can raise an uncertain tax position, and that goes in your financials. So if SARS picks up your financials in an audit, that's a lovely red flag for them to start conducting the audit. So that's the first thing. So generally, where there is an uncertain tax position, auditors will request a tax opinion to support the taxpayer's tax position, and that kind of sorts it out. It goes in a file, and that's good going forward for everyone to see why that tax position was taken. So that's on the internal sort of point of view. But then we get to the tax disputes with SARS, and this is where we have to discuss the quality of tax opinions that are obtained. Because if you have a 2-page tax opinion that just regurgitates the law, does not apply to the facts, and there's sort of a conclusion that, well, this is the correct tax treatment, how helpful is that down the line when there is an actual dispute with SARS? So what you do want, obviously the point of a tax opinion, especially in the context of a dispute with SARS, is that you can actually have a defense on the merits of the dispute. So you can say to SARS, they're conducting their audit, you can say to them, listen, this is why we've taken this tax position, and hopefully if it's sound, they go away. But then if they don't, then you actually have a basis for your defense for the tax court dispute or any subsequent appeals, right? So now that's on the merits. So I think let's move on to the understatement penalty bit of that. And we'll also just talk about legal privilege, but I think that kind of comes on the end of it. So for your understatement penalties, you've got 2 types of opinions. You can get just a normal tax opinion that's signed off, or a 223 opinion that's issued by a registered tax practitioner. Now, so for an ordinary tax opinion that's not issued in terms of Section 223, this can help you with understatement penalties where you are pleading a bona fide inadvertent error. So if the tax court or any subsequent court does find that on the merits, your argument falls apart, then they must remit the understatement penalty if it's as a result of a bona fide inadvertent error, okay? If you have a 223 opinion that meets the requirements of 223, and that SARS is satisfied meets the requirements of 223, then SARS must also remit that penalty. And we'll have a discussion about what kind of penalty that is in a moment. But for 223 to apply, you must have the opinion issued by a registered tax practitioner. It must be issued before the date the return was due. All of the facts and circumstances must have been disclosed to the tax practitioner, and the tax practitioner must have confirmed that in his or her view, more likely or not, that tax position will be upheld by a court. So let's talk about, well, when you have a 223 opinion, must SARS actually remit the penalty? And the answer is not necessarily. So SARS must be satisfied that these requirements are met. And if SARS decides, well, they're not satisfied, they can go ahead and levy the penalty, and that is subject to objection. So you can then go and object and appeal against that decision by SARS. And the question then becomes, for 223, if you have an understatement penalty that's levied on you, that's not an understatement penalty as defined, which is the disputed tax is either more than 5% of the understatement or more than $1 million, must SARS then, will 223 then apply? So must SARS still remit the penalty? And there's a bit of uncertainty on this. We know that SARS, in SARS's view, 223 only applies where there's an understatement penalty. So if you fall into any of the other behaviors in the understatement penalty percentage table, such as no reasonable tax position taken, impermissible tax avoidance, etc., their view is that 223 will not help you at all. However, there is an opposite view that 223 should still come to your assistance, because 223 specifically makes reference to an opinion issued in respect of the GAR provisions, and that would fall typically under impermissible tax avoidance. And that's what they would have to prove, that it's an impermissible tax avoidance arrangement to apply the GAR provisions. So then the question becomes, if you do have an additional assessment that's issued and SARS has invoked the GAR provisions and you have a 223 opinion, should you then be able to escape the understatement penalty based on section 223 of the TAA? Well, we don't know. It hasn't been specifically kind of fought out in court or decided by a court as yet, but our view would be yes, because 223 does make reference to impermissible tax avoidance arrangements. So then it should cover all of the sort of behaviors in the understatement penalty percentage table. So on the issue of the tax opinions that are not issued in terms of 223, so if you just have a normal tax opinion by a tax advisor who may or may not be a registered tax practitioner, or they have not done the confirmation in terms of 223, and then you come in and say the penalty should be remitted because it's a bona fide inadvertent error, the question then becomes, well, what is a bona fide inadvertent error? Now, we know the tax court has said it's an innocent misstatement by the taxpayer, but SARS has taken a different route in the understatement penalty guide, where they have said they don't think an error can be inadvertent if a taxpayer has done deliberate tax planning and has deliberately taken a tax position as a result of advice that they've received. So they said, well, this cannot be an error. You intentionally sought out this advice and you intentionally took this tax position. So again, there will be kind of a back and forth between the taxpayer and SARS about what constitutes an inadvertent bona fide error. This was considered by the courts recently in Coronation and Thistle Trust. Now, we know the SCA sort of found in favor of the taxpayer on the issue of the understatement penalties. And specifically in Coronation, the taxpayer did not have a 223 opinion. However, the court found that because the taxpayer was in possession of a tax opinion that supported their tax treatment, that there could be no mala fides attributed to the taxpayer, and therefore the understatement penalty was remitted. And in this case, the tax opinion actually wasn't even disclosed to SARS, and there was no obligation on the taxpayer to do so because it was not a 223 opinion. However, this is now being appealed to the Con Court, so we will have to see where this goes when eventually the Con Court kind of decides on this appeal. The third issue I think that's very important is the timing of the disclosure of an opinion and legal privilege. So where you have a 223 opinion and you want to rely on section 223, then you will have to disclose it to SARS, because SARS must satisfy itself that you have met the requirements of 223 and therefore that the penalty should be remitted, or if they have not satisfied themselves, then you can then go on and object against that decision. But where you just have a normal tax opinion and it's not issued in terms of section 223, and it is subject to legal privilege, generally the view is that then you are not forced to disclose it to SARS because it's part of legal advice between attorney and client, etc., etc. And this is sort of where the difference between getting an opinion from a practicing attorney or somebody who is registered with the LPC versus, say, another tax advisor who isn't a practicing attorney, who might be an accountant, etc., would make a difference. Because obviously, if you got an opinion from someone who isn't registered with the LPC, that would not be subject to legal privilege, and SARS can ask you for the opinion, and well, you could dispute that you have to hand it over. You could say it's not part of relevant material, etc., etc. However, if it is legally privileged, then you could just raise the defense of privilege and that goes away. And I think that's important because it's the timing of the disclosure and the decision about whether you're going to disclose it at all. So at the point where SARS comes and knocks on your door and starts an audit, and you kind of give them your merits and say, well, this is why I've taken this tax position. Is a tax opinion relevant material to conduct the audit? Now, we have seen SARS recently allude to that a tax opinion is relevant material for their audit. So they have come and asked the taxpayer, well, this disclosure that you've made, did you get a tax opinion? And if so, could you furnish us with the tax opinion? Now, if it is a legally privileged opinion, our view is that you don't have to provide it at this point. Or if you think, if it's best, depending on the facts and circumstances, that providing this opinion will make the whole thing go away because it's a simple matter, then, you have to sort of weigh the considerations in that case. But for instance, where your opinion was issued and it was subject to assumptions or a caveat of some sort, then maybe you would not want to provide that opinion. Or if the opinion canvasses kind of more issues than what SARS has raised in their audit, it will obviously not be in your best interest to disclose the opinion at that point in time, because you would obviously flag more issues for SARS to raise as part of their audit. Now, if we move on after SARS has issued the findings and it's time, and they've issued an additional assessment, and now you are at the point of the dispute, do you then give over this legally privileged opinion? Is it still worth your while? Or do you say, well, I am in possession of an opinion, however, it is legally privileged, and then make a decision about whether to disclose the opinion to SARS further down the line in the dispute? So this is part of your dispute strategy, depending on the contents of your opinion, the nature of the dispute, etc. But it's always in your best interest to have a legally privileged opinion so that you are free to make those kinds of decisions. And this goes back to the issue of your internal risk management. So when your auditor knocks at your door and asks you for a copy of your opinion so they can make sure that there is no uncertain tax position, when you give the opinion to your auditor, the question is, have you now waived legal privilege? And this is another question that SARS has asked in their audit when they say, can you provide us with copies of tax opinions and also let us know if these tax opinions have been provided to your auditors? Because that is obviously the road that they're going down, that if you've provided this to your auditor, you have waived legal privilege. So if you try to raise this defense of legal privilege, then you might not be able to. Now, there is some case law in some jurisdictions in Australia. They recognize the concept of a limited waiver of privilege. So they say, if you provide the opinion to, say, an auditor in the context of conducting an audit, then you've waived legal privilege only in that limited instance and not for general third parties to now claim a waiver of your legal privilege. So when you have got an opinion before there's a dispute and your auditors come knocking at the door and say, listen, we want to see something, a 223 opinion or something from an advisor saying that this is the correct tax position, it's probably not wise to actually give the opinion to your auditor, but maybe to walk them through the contents, the reasoning, and just confirm to them that you are in possession of a tax opinion. That should be sufficient, because you don't want to then find yourself in the position later down the line when there is a dispute that you have now waived legal privilege and SARS can somehow get their hands on this. So if the coronation judgment is upheld, that would be very positive for taxpayers, because then it should be sufficient to say simply, I have a tax opinion, it confirms the tax treatment that I've taken, and therefore I've acted in a bona fide and responsible manner. And if I'm wrong on the merits, then you should still waive these understatement penalties. But we don't know where that's going to go. So I think from the start, when taxpayers start doing their tax planning and doing their their risk management, they should keep in mind what's coming down the line, because unfortunately things are done at that stage already, or an opinion is obtained and it has assumptions in it, or there's a caveat in it, and nobody kind of flags that. And at the point where a dispute arises, that becomes an issue. So even if it is a 223 opinion and you hand it over to SARS, they will say, well, you did not disclose all the facts and circumstances to your tax advisor, and therefore this doesn't meet the requirements of 223. So from the very beginning, when obtaining a tax opinion, taxpayers need to keep this in mind, that if this does kind of crystallize into a dispute down the line with SARS, how are we going to treat this opinion? What do we want this opinion for? So first of all, it needs to give a proper consideration of the merits, a proper consideration of the law, applying the law to the facts, and a proper conclusion. Because if you just have something flimsy and then 10 years later SARS comes knocking at the door and you go back and you try to reconstruct, you know, what the merits were or what your view was, then you might have run into a bit of trouble. So that's the first thing. Second, you want to think about, if there are understatement penalties somewhere down the line, is this opinion going to hold up to the requirements of 223? That's the first thing. And the third thing is this opinion legally privileged? So will I then have to hand this opinion over to SARS at some point? Will I have to hand it over to them at audit stage? So if they say it's relevant material and a court agrees with them or decides that it is relevant material and you hand it over at that point, is it giving away more than what the scope of the audit would be? A, and B, would it actually support your contentions in a very thorough manner? So if SARS can still poke holes in it and say, well, you didn't cover this or you didn't cover that, that's also quite bad, because if you have too much information or information that could be beyond the scope, that would be bad. But if you have insufficient information in the tax opinion, that could also be quite unfortunate for you, where a dispute does crystallize along the line. So I think it seems like an easy thing, and when people, you know, they obtain their opinions, they go, they get the opinion, they put it in the file and they forget about it. They say good enough for the audit, tick, and we move on. But at the point where dispute actually arises, that is where these considerations actually become very important, because, you know, obviously the understatement penalties could be quite significant. They're not insignificant. And two, for the merits of the matter as well, your tax opinion will become quite important. So I think it's very important for taxpayers at the very beginning to keep all of these things in mind. And when obtaining a tax opinion, know what you need in the opinion, what should not be in the opinion, and who should prepare the opinion for you. So that's it from me. I think, Taryn, over to you.
Thanks, Ntebaleng. I'm going to get into a little bit of the nitty-gritty of the tax court rules. I'm just going to share some slides with you. Okay, so we had new tax court rules which took effect in March this year, and although there weren't many substantive changes, we've just decided to pick out a few which we'd like to draw your attention to, where the changes are more substantive ones. So the first, probably the most substantive change out of all the rules, is the extension of the time period to lodge an objection. So previously, a taxpayer had 30 business days within which to lodge its objection. This has been substantially extended to 80 business days. I mean, that's more than double the amount of time which a taxpayer now has. So we think I think the reason for this change is twofold. One is SARS was likely getting many extension requests, because 30 business days is not such a long time for a taxpayer to consider its position following the receipt of an assessment or an appropriate or relevant decision. And also, an objection is arguably one of the most important documents in a tax dispute, where a taxpayer has the opportunity to set out its grounds, which it's going to have to rely upon for the entire dispute. So 80 business days, you know, is quite a positive change for taxpayers. But what's important to consider is other sort of related time periods haven't changed. So a taxpayer can still request extensions for the submission of an objection, and the requirements are, if that extension is less than 30 days, you can request that extension on reasonable grounds, and if it's more than 30 days, that request, you can request it if there are exceptional circumstances. However, because the length of time which a taxpayer now has to submit its objection has extended so greatly, these extension requests are going to have to be very strong and well motivated. And I think SARS would probably be less lenient in extending, because a taxpayer now has a significant amount of time to prepare the objection. What a taxpayer can always do before submitting an objection is to request reasons for an assessment. The request for reasons time period has not changed. A taxpayer still only has 30 business days to submit its request for reasons. So even though you've got more time to think about your grounds, you still have to consider quite quickly when you receive an assessment whether there's anything you need or want to ask SARS in order to prepare your objection. And then finally, how does this interact with suspension of payment applications? So we all know there's the pay now, argue later in our tax rules, and just because you're disputing an assessment doesn't mean a taxpayer's obligation to pay is suspended. So a suspension of payment application needs to be submitted on or before the due date of when an assessment becomes due and payable. And now that is going to be quite a lot shorter, or that period is going to come quite a lot sooner than the new submission date for the objection. Previously, the objection submission and the suspension of payment application submission, the dates were quite similar. And now there's going to be quite a big difference. So a taxpayer needs to focus on its suspension of payment application, get that in, and then kind of focus on the objection. And I just wanted to bring Simon in here. I know he's going to speak about suspension of payment applications a bit later, but I know there's also some practical difficulties with SARS in respect of the objection submission versus the suspension of payment.
Yeah, that's quite right, Taryn. So what happens is that you submit your application for suspension of payment, but at that stage, there's no objection yet that's on the system. So it seems to be that, the SARS system generates a message, or, it has a check and it says, well, oh, no objection has been lodged. And of course, you can only apply for suspension of payment if you intend to dispute the tax. So there's that sort of system issue that still needs to be tweaked. What we've seen is that in that instance, if we do get that letter that says, invalid suspension of payment request because there's no dispute, to SARS's credit, if you engage with them, if you engage with the auditors, they usually assist you with that. But it's still annoying that you have to go through that process for something that, seems like an easy fix.
Yeah, absolutely. The second change, which I just wanted to mention, is one of the requirements for an objection. So previously, one of the requirements in your objection is that you should specify the substantiating documentation, or the documentation that you're going to be relying on in an objection. There's been a slight change to that, where now one of the requirements is to submit the substantiating documentation. So maybe practically this isn't such a big change, because a taxpayer would usually have gone through quite a substantive audit with SARS prior to issuing of an assessment, and a taxpayer probably would have submitted all necessary or relevant documentation. However, we must just bear in mind that it's now a requirement for an objection that a taxpayer submits its substantiating documentation. So we must just be mindful when drafting objections to do that, as we wouldn't want an objection to be deemed invalid just because substantiating documentation wasn't submitted with the objection. Nothing's changed in terms of Rule 8. SARS is still afforded the power to request any additional substantiating documentation, and also nothing has changed regarding, you know, way down the line when you're approaching the tax court, when you're approaching your hearing, and the discovery rules, where each party must give forward to the other party relevant documentation for the dispute. So that's just a minor change to the objection rules. Yeah, there's some new wording in Rule 10, Rule 31, and Rule 32. It doesn't seem like this is a substantive change, but rather just wording has been changed, you know, couched in the positive as opposed to the negative. But I thought I should just point this out and go through it, because these are actually quite interesting provisions. So Rule 10 deals with a taxpayer's notice and grounds of appeal. So that's after your objection is disallowed, the taxpayer can submit an appeal. And Rule 10.3 says the taxpayer may appeal on a new ground not raised in the notice of objection unless it constitutes a new objection against a part or amount of the disputed assessment not objected to. So that's why, as I said previously, your objection is a fundamental document in the process. That is where you get to set out your grounds. So even though you may raise a new ground in your notice of appeal, that cannot constitute a new objection. An easy example of that, for example, if an assessment contains a disallowance of a deduction and an understatement penalty, and in your objection you only object to the disallowance of the income tax deduction and not to the understatement penalty, you can't then appeal the understatement penalty in your notice of appeal. That's kind of always been the rule. The wording has just kind of been couched positively now. The Rule 31 statement is SARS's grounds of assessment and opposing appeal. That's the SARS pleadings in the tax court. This is quite wide, and it has always been, and subject often to dispute or controversy. It states that SARS may include in the statement a new ground of assessment or basis for partial of allowance or disallowance of objection, unless it constitutes a novation of the whole of the factual or legal basis of the disputed assessment or requires the issue of a revised assessment. So SARS actually have quite wide discretion here to include new grounds in their grounds of assessment at a very, very late stage of a matter. You know, before an assessor assesses a taxpayer, they're meant to, you know, be satisfied and make the decision of the grounds of assessment. But here, the wording, the positive wording here is allowing SARS to, you know, kind of add to their case very late in the day. Pete, did you want to comment on this?
It did. And we see this as well. We see it in practice. And as you say, you're kind of a long way down the track and you've done your objection and you kind of, you know, you sort of think you're going along the N1 and next thing you're taking a side road and you're going along the N2. And this is, you know, so first of all, it's quite a high threshold for to say SARS can't do this, because for them not to do it, it needs to be a novation of the whole of the factual or legal basis. So they've got a lot of wiggle room there. And we actually see them doing this in practice. So I think just to be very careful, you know, when you get your Rule 31, don't just assume that this is going to be a rehash of the process that you've been through and the letter of audit findings, etc. You can find some very interesting changes in the Rule 31 statement, which of course is the start of your pleadings.
Absolutely. And then I'm not going to go into detail. The Rule 32, which is the taxpayer statement, the wording is similar to the notice of appeal rules. So previously, the taxpayer and SARS could always agree to extend time periods and not fight about things and just agree that each party has more time to do something. There's also now the opportunity to shorten time periods. So I think that's positive, and matters can be sped up by agreement. Then ADR proceedings, they're often not seen as very successful. We haven't had, you know, much success or joy out of them. And I think there is kind of a desire within the SARS structures to make the ADR, you know, more productive and more of a success to resolve disputes. So some of the rules have been amended to take this into account. I've just picked out a few. There's a more collaborative process regarding the appointment of the facilitator, who must be acceptable to both sides. There's now a concept of an interim and a final report, and perhaps that's, you know, to give the parties the opportunity to comment before the report is finalized. And a third one, which I picked up, which is quite interesting, is a court can no longer direct the issuing of subpoenas of persons involved in ADR proceedings and to compel them to disclose representations made or documents tendered during the ADR. So I think this is quite positive, and it may encourage then people to take ADRs quite seriously and to really make an effort to try resolve or settle matters, because that information cannot, you know, be used against you. You can't be subpoenaed to a court to use that information afterwards. They've always been without prejudice proceedings, but now a court cannot direct the issuing of a subpoena to someone who gives evidence at an ADR. Giving effect to tax court judgments, also a positive change. The registrar must deliver written notice of the judgment within 10 business days of it being delivered, as opposed to 21. And also really positive is that SARS is now compelled to issue assessments to give effect to a tax court's decision within 45 business days. So often it takes a long time to actually finalize a matter after the tax court hearing and judgment, and this kind of forces SARS to speed things up. They now have to stick to a timeline. Finally, the transitional arrangements of the new rules. There's just a couple of pointers. The new rules apply to all current dispute proceedings without prejudice to whatever was done under the old rules. New procedures can be conducted under the new rules, provided the time period hasn't expired. So just as an example, if you have an objection that had already expired, or 30 days was up by the 10th of March, you can't then get an extra 50 days to object. However, if you are on day 25 and the 10th of March arrived, you were able to take advantage of the additional days in the new rules. So yeah, I think that's kind of where we've landed in terms of the new rules. And then I just want to hand over to Simon to deal with suspension of payment, which is always quite a exciting but stressful area for our clients and taxpayers.
Yeah. So as you've mentioned, Taryn, obviously there's now been quite a generous extension in the days to lodge an objection. And I think that one of the big advantages of that is perhaps unintended, is that it does allow you that initial period to actually work on your suspension of payment application, and to make sure that, you know, you get in a comprehensive and robust suspension of payment application, and you don't have to take that time to work on your grounds of objection, and you know, formulating that, because as you said, it is such a crucial document. I think Peter has previously described it on occasion as, you know, your first big fight with SARS, and I think that's a very apt description. So of course, we know what the pay nor argue later principle entails. Obviously, if you receive an assessment, you know, the debt is created and it becomes payable to SARS by the due date, and that is so even if you intend to dispute the tax. But even though that is the position in terms of the Tax Administration Act, the Act, of course, does allow SARS to suspend the payment pending the resolution of the underlying dispute. Now, you know, we've helped over the years many clients with their applications for suspension of payments. And, you know, a few times we've had the question from clients who've asked us, but, you know, why submit a suspension of payment request to SARS? Perhaps, you know, they've got the cash, they can just settle it, you know, pay it and fight the tax assessment through the procedures. And I think that there might be some merit to that argument if you think about the fact that if you are successful with the dispute, SARS must repay the capital together with interest, and the interest rate there is relatively high. But what we found is that, you know, paying a disputed tax debt at that early stage often changes the dynamic of the dispute process. So especially later on, where there are settlement negotiations between the taxpayer and SARS, Of course, understandably, SARS may be quite reluctant to settle on a basis where, that would result in any refunds becoming due to the taxpayer. So you could say a suspension request signals very early on to SARS, even before the objection is lodged, that the taxpayer is really aggrieved by this assessment and it doesn't agree with that assessment. That the taxpayer knows its rights and it's willing to exercise them. Secondly, as Peter's previously mentioned, is that the tax court procedure can take anywhere from 2 to 3 years. So I mean that's quite a long time, and I think certainly for most taxpayers that cash could be better used for its business purposes. So no real use tying that up. Another reason I think why a suspension of payment should generally be considered in the circumstances is understatement penalties. We've seen from SARS that understatement penalties are sort of imposed as a knee-jerk reaction with not a lot of thought going into it. And in most cases, it's based on 50%, which is certainly SARS's favorite behavior to impose understatement penalties on. But here, of course, it should be remembered that SARS bears the burden to prove the understatement penalties. So, to me personally, perhaps it doesn't really make sense that you should be required to pay something such as a penalty when SARS is yet to prove that in any subsequent tax court proceedings. I've looked at SARS's latest service charter, and it promises that 60% of cases or applications for suspension should be resolved within 30 days of its decision, and SARS should then grant its the outcome of that application within 30 business days in 60% of cases. But I mean, in our experience, it takes much longer than that. And there's sometimes also a bit of back and forth with SARS, after the application has been submitted, where SARS comes back and asks for further information. And I mean, the benefit, of course, in that is that once you've submitted that application, the position in terms of the Tax Administration Act is that the debt is what we sometimes refer to as automatically suspended. So what that means is that the ball is really in SARS's court, and SARS cannot take enforcement action from the date that you've submitted that application until 10 days after SARS has communicated the outcome of its decision to the taxpayer. And I mean, as I've said, the default position is that the debt is enforceable, regardless of that intention to dispute. But then, of course, there is the possibility to ask SARS to suspend that. And then SARS, would make that decision having regard to the circumstances under 1643 of the TAA. And I don't think that that's a closed list, but what certainly our experience is that SARS sort of looks at that, and it doesn't really consider anything else that might be of relevant. And although you can also make the case that the merits is also something that's important. The merits of your underlying dispute is also something that's important in, deciding whether to suspend payment or not. We haven't really seen SARS actually looking at that. Rather, what we generally see is that in most applications, SARS focuses on, paragraph D, whether payment will result in irreparable hardship to taxpayer not justified by the prejudice to SARS or the fiscus if the disputed tax is not paid or recovered. And like I've said, SARS in most applications, when you do get an outcome, they usually would say, they often conclude that payment won't result in irreparable hardship. But obviously, I mean, if you look at the wording of that subsection, the fact that quite clearly requires a weighing up exercise of the hardship to the taxpayer on the one hand versus the prejudice to SARS or fiscus on the other hand. And in these outcomes that we've received, I've never actually seen SARS making out a case or even alleging what the basis of its prejudice or the prejudice to the fiscus would be. And in this context, because it is such an important factor, especially from SARS's perspective, the question then arises, what exactly is irreparable hardship? certainly if you just have regard to, if you, on a cursory reading of the word, it does suggest quite a high threshold. Does it mean, for instance, that, you know, you need to show if you pay the disputed tax debt, then, you know, it might end up in insolvency or retrenchments. But I mean, obviously those things would be irreparable hardship, but our view is always that the threshold is not quite that high. I mean, I think that if you can really show that paying the disputed tax debt will, you know, hamper the business operation or potentially its growth plans, then you have a case to argue that there will be irreparable hardship for purposes of this factor. But, you know, it all really depends on the circumstances of the case and how you actually package that to SARS, taking into account the environment within which you operate, and how you get that across to SARS in terms of your application. In terms of outcomes, our general experience is that it's not uncommon for SARS to grant partial suspensions. So either, you know, 50% or 75% is I've also seen, and then it requires that to be paid in certain installments. Now, on my reading of the Tax Admin Act, and you might disagree with me on this, I don't really think that there's a basis for granting those partial suspensions, and I think it's more sort of a practice that has developed within SARS. What has also become a bit more prevalent of a practice by SARS lately is what I can call time-coupled suspensions, where you'd find SARS say that, you know, we'll suspend payment for a fixed period, and after that you need to come with, you know, need to return with a further application. But again, I don't think that there's any specific basis for that in terms of the Tax Administration Act. Rather, the Act contains specific provisions in terms of which SARS may revoke a suspension of payment previously granted. And although this is not specifically legislated in the Tax Administration Act, one would think, you know, as a basic and fundamental principle of our law, that, you know, SARS must really give you an opportunity to make representations on why a previous suspension has not been, should not be revoked or reconsidered. So I'm aware that we've reached time, so if you'll maybe just bear with me for another 5 minutes. And then, as Andries also mentioned in the beginning, you know, the question about recourse. What exactly do you do if, you know, you think that SARS has taken a decision that's unreasonable or irrational, or, you know, not really permitted in terms of the operative provisions? And this is, of course, a valid question, because what are rights exactly if you can't enforce them? And I think on that score, it's now fairly well accepted that when SARS takes a decision on suspension of payment application, that is an administrative decision that is potentially subject to review in terms of the Promotion of Administrative Justice Act, or PAJA. And this principle is recently confirmed by a High Court in SARS versus Agritsi, where the court said, you know, it is an administrative decision that is reviewable in terms of PAJA. Interestingly, in that case, the High Court found that SARS's decision to refuse a suspension of payment was irrational, and that SARS had failed to consider relevant factors, with the result that the decision was set aside and referred back to SARS for reconsideration. It'd be interesting to hear what the actual outcome was after SARS reconsidered it. I would have thought that, you know, it was quite difficult for SARS in that instance to refuse it, given what the court's findings were. So then your recourse in that circumstances could potentially be a review application in the High Court, where you ask the court to review and set aside, or even potentially substitute, SARS's decision to refuse a suspension, or to allow a partial suspension. I mean, you'd have to look at the circumstances and also consider SARS's reasons for, you know, either declining a suspension or only granting a partial suspension. And then also, you know, it's possible that if SARS refuses to suspend payment pending your High Court review application, there's also the opportunity for you to approach the court, you know, for an interdict prohibiting SARS from taking any enforcement actions pending the review application. And that portion could also be brought on an urgent basis, again, depending on the applicable circumstances of the case. And then, yeah, I mean, as Andries has said at the beginning of this webinar, is that SARS is quite aggressive. And my personal view is that I think that, you know, SARS might become a bit more sticky on granting suspension of payment applications. And I wouldn't be surprised if there's also concomitantly an uptick in the amount of review applications brought by aggrieved taxpayers in the High Court. So that's all from me.
Thanks so much, Simon, and thanks to everyone for joining us today. And I think there have been some questions in the Q&A box, but we have run out of time, so we will address those offline. Yeah, and that's it from us. Thanks, everyone. Cheers.
Thanks, everyone. Cheers.